All right, good afternoon, everyone. I'd like to declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the Criminal Code Amendment, State Sponsors of Terrorism Bill 2025. These are public proceedings, although the committee may agree to request to have evidence heard in camera or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of the evidence given to a committee, and such action may be treated by the Parliament as contempt. I remind all present, as Chair, I'll ensure the proceedings are conducted in an orderly, respectful and courteous way. In accordance with the committee's resolutions of the 26th of August this year, the hearing will be broadcast on Parliament's website, and the proof and official transcripts of proceedings will be published also on Parliament's website. The hearing today has been conducted predominantly by video conference with some witnesses, I think all the witnesses are in Canberra, and members on video. Members and witnesses participating remotely are reminded to mute to mute microphones when not speaking. I'd like to now welcome representatives from the Attorney General's Department and the Department of Home Affairs. Good afternoon. Now, can I ask for the Hansard record, could you all please state your full names, the capacity in which you appeared before today's committee hearing? And we'll start with the Attorney General's Department.
Thank you, Chair. Sarah Samios, First Assistant Secretary, Integrity and Criminal Law Division, Attorney General's Department.
Good afternoon. Luke Muffet, Assistant Secretary, National Security and Criminal Law Branch, Attorney General's Department.
Good afternoon. Liam Flannery, Director, National Security Section, Attorney General's Department.
And good afternoon, Gemma Smythe, the First Assistant Secretary of the Counter-Terrorism and Violent Extremism Division at the Department of Home Affairs.
Good afternoon, Madeline Casey, Assistant Secretary, Counter-Terrorism and Violent Extremism Division, Department of Home Affairs.
All right, thank you. Now, although the committee does not require you to give evidence under oath, I should advise that there is a legal hearing or legal proceeding of the Parliament, and therefore has the same standing proceedings of the respective houses. Given false or misleading evidence is a serious matter, may be regarded as contempt of Parliament. The evidence given today is recorded by Hansard and attracts parliamentary privilege. As you'd be aware, due to the short time frame the committee is working within to complete its review, please try and answer all questions or provide information to the best of your ability in the evidence today. As written answers to any questions taken on notice will have to be provided within 24 hours of receiving the Hansard transcript. Now, I just want to ask, did either department have an opening statement?
Thank you, Chair. I have a short opening statement for the Attorney General's Department.
Excellent. Thanks. Proceed.
Thank you. The Attorney General's Department welcomes the opportunity to appear before the committee as part of the review of the Criminal Code Amendment, State Sponsors of Terrorism Bill 2025. Australia continues to face a dynamic and complex security landscape. Following the Australian Security Intelligence Organisation assessment that foreign state actors have directed attacks on Australian soil, the government committed to implement a framework specifically designed to respond to this threat by providing for the listing of a state entity which engages in terrorism targeted at Australia. The bill delivers on that commitment. The Criminal Code contains an existing framework under Part 5.3 to list certain organisations as terrorist organisations. The framework remains an invaluable tool to publicly condemn those organisations and criminalise conduct connected with terrorist acts and interacting with listed organisations. It does not apply to foreign state entities. This bill would amend the Criminal Code to create a specific State Sponsors of Terrorism framework under new Part 5.3 A to deal with state terrorist acts and state sponsors of terrorism. The framework would replicate and adapt the existing terrorism framework provided by Part 5.3 to enable the Australian Government to list a foreign state entity as a state sponsor of terrorism. It would introduce a range of offences criminalising engagement in or support for state terrorist acts involving a listed state entity, or where a state sponsor of terrorism has supported a non-state entity to engage in terrorist acts, with appropriate defences and safeguards. It would introduce a range of offences criminalising certain interactions with a state sponsor of terrorism or a member of a state sponsor of terrorism, with appropriate defences and safeguards. And it would ensure that law enforcement and intelligence agencies have access to the powers that are currently available for terrorism to respond to and prevent state terrorist acts. The bill was developed in close consultation with the Department of Home Affairs, the Department of Foreign Affairs and Trade, the Australian Federal Police and ASIO. The departments of the Prime Minister and Cabinet, Treasury, Defence, Industry, Science and Resources were also consulted throughout the development of the bill, reflecting the wide range of consequential amendments that were required. Consistent with section 100.8 of the Criminal Code and the Intergovernmental Agreement on Counter-Terrorism Laws, State and Territory First Ministers have been asked for their approval for changes in Schedule 2 of the bill, which would expand the application of control orders, preventative detention orders and post-sentence orders to the new framework. To facilitate this approval, states and territories were also consulted in the development of the bill. Lastly, it may assist the committee if I outline the division of responsibilities between the Attorney-General's Department and the Department of Home Affairs in this matter. The Attorney-General's Department administers the Criminal Code Act 1995 and is responsible for the development of the bill. The Department of Home Affairs would be responsible for supporting the AFP Minister in making any decisions under this framework. Thank you again for the opportunity to appear and for your consideration of the bill, and we're happy to answer questions.
Okay. Did the other department have any question? An opening statement?
No, Chair, no opening statement from the department.
Okay, excellent. Now, Mr. Wallace, Deputy Chair, you have the call.
Thanks, Chair. And just for the record, I just want to make sure that the Secretariat have picked up that Senator McDonald is on the line as well.
Yeah, it will be picked up. Thanks, Deputy Chair.
Good, thank you. Thanks for your attendance this afternoon. Look, I know this is probably a pretty basic question, but what I would like to do, and I might go to you first, Ms. Samios, is just start off with a basic introduction of why we need this bill.
Thank you, Senator. I think to some extent it was covered in the opening statement, but maybe Mr. Moffat would like to expand a little on the opening statement.
Yeah, thank you, Deputy Chair. So really what this bill is addressing is an issue with the current framework which deals with terrorist acts and terrorist organisations. So currently that framework in Part 5.3 of the Criminal Code does not allow organ of a nation state to be listed as a terrorist organisation. It's really dealing with the acts of non-state entities. Given the recent events, there is a clear need to deal with the threat posed by nation states, targeting Australia and looking to engage in terrorist acts towards Australia. So what this regime does is sits parallel to the existing terrorism framework and really creates a framework through which terrorist acts engaged in by state actors are criminalised, as well as providing a framework for the listing of state entities as state sponsors of terrorism, which is the language we use in this framework, which is the equivalent of a terrorist organisation, to allow them to be listed and then therefore criminalise certain actions with, in relation to those entities.
Yeah, okay, thank you. Apart from the anti-Semitic attacks that were recently attributed to the IRGC, are you aware of any previous instances of state-sponsored terrorism in Australia? And if so, how are those incidents dealt with under any contemporary laws?
So to answer your second question first, there are a range of criminal laws that would and have always captured violent or harmful acts in Australia, whether they are property damage or harm to individuals. They are crimes. Really what this is doing is recognising that sort of elevated, aggravated level of criminality in the form of terrorism. In terms of past actions, look, I would, in that case, defer to my intelligence sort of counterparts, and I want to be very careful about what we sort of say in a public forum on that. But the Director General of Security has been very clear in his annual threat assessments and his various speeches about the sort of increasingly sort of diverse and complex nature of the threat environment, and how sort of threats are becoming hybrid and interrelated.
Yeah, okay, thank you. You spoke earlier, Mr. Muffet, about the structure, and I'm particularly keen to explore why the bill was structured in the way that it was. So we've basically got two parallel systems running if this bill proceeds. I'm keen to understand why that process was undertaken rather than trying to include in state-sponsored terrorism in the existing structure. Does that make sense?
Yeah, no, look, it does. So the way we've approached it is really to have, like I said, a parallel part. The decision there, there's obviously many different ways you can progress legislative reform. The decision here was taken to do a parallel part to ensure that we can deal with the complexities and sort of unique context of state sponsors of terrorism. It is different in nature. There are different sort of protections and different assessments needing to be made to deal with that new paradigm. And it was ultimately determined that the most effective way to do that and the way to do it in the most sort of targeted and appropriate way was to do a parallel part. Now, there is obviously a lot of similarities between the two parts. Just to comment briefly on that, the idea here is really to complete the circle. At the moment, we have a framework for dealing with terrorist acts and terrorist organisations, being those that relate to non-state actors. In this new situation where we have state actors engaging in terrorism targeted at Australia, it's really ensuring that irrespective of whether it is a non-state actor or a state actor, there are appropriate criminal offences that apply. So that's why there is a lot of parallels between the two, but the second part deals with the uniqueness of a state actor.
Were there any concerns as to why you went with the parallel system? Were there any concerns about the legality or constitutionality of the second process for state-sponsored terrorism, state sponsors of terrorism?
No concerns about that. We're very confident the bill has sound constitutional support. In fact, the approach we took was to deal with concerns about the particular context of states and making sure we had appropriate the framework was appropriately targeted and we had appropriate safeguards in place to deal with that unique nature of states.
Are there any... I don't want to move from this parallel thing yet because I really want to drill down into that and just make sure that the committee is comfortable with the architecture of it. On whose advice did the AGD, was it internal advice that you relied upon that this was the most appropriate way to set it up with the parallel system? Or did you brief that out?
I mean, Senator, it's ultimately a policy question. So it was developed by AGD, certainly in consultation with all the partners we spoke to. Do you think it's a policy question? So, I mean, the question of whether it's lawful is a legal question. The question of how you structure it is a policy question, I would think.
Okay, all right. Well, we'll agree to disagree on that, but that's okay. Mr. Muffet indicated that there was a lot of similarities or duplication between the provisions between state and non-state. How is the term Terrorist Act currently defined in the Criminal Code and in the Crimes Act, and how will these definitions change if the bill is passed?
Senator, I'll deal with the...
I'm not a senator.
Sorry, Deputy Chair, Mr. Wallace. Let me...
No, I definitely wouldn't.
Let me deal with that in two parts, because it is sort of a different question in the Crimes Act to the Criminal Code. So currently, Terrorist Act is defined in 100.1 of the Criminal Code to deal with certain acts which, to paraphrase, acts or threats of actions targeted at harming people or harming property in a serious way, where that act or threat of action is intended to advance a political, religious or ideological cause, and finally where that is intended to coerce or intimidate the government or the Commonwealth Government or a state or territory government, or intimidate the Australian public or a part of the Australian public. The definition, so that is for current definition in the Criminal Code. What this bill does is insert, again, a new definition there, which is identical to that definition, but for one aspect. So I won't repeat it all. I'll just talk to the difference. What Terrorist Act is, how it differs in the new part, or in relation to state sponsors of terrorism, is excludes actions undertaken in the context of and associated with international armed conflict. So the idea here is when we are talking about terrorist acts undertaken by state actors, where that is undertaken in an international armed conflict, there is a series of laws already in place, both in international law and domestic law, to deal with that context. So international humanitarian law, and domestically we have a series of sort of war crimes and other offences that deal with criminality in an international armed conflict situation. Really what this is doing is addressing that part of the spectrum shy of international armed conflict, and that criminal part of the spectrum outside of international armed conflict. In terms of how the bill affects the definition of terrorist act in the Crimes Act.
So before we go to that,
Yep.
can I, unless you've got something very simple to say on that?
Look, let's park that because that will take us down a path. So let's finish the other one first.
Good. Okay. Thank you. How is the international armed conflict defined in the Act?
It's currently not defined. It is a term used throughout the criminal code already. Like I mentioned, those war crimes offences, a spectrum of those war crimes offences only apply in the context of international armed conflicts. And these offences we are talking about here in state terrorist acts don't apply in international armed conflicts. So it's about taking us up to that threshold, and then the war crimes take over from that threshold. But it's not defined, but there's significant sort of international law jurisprudence there around what the definition of an international armed conflict is.
What would happen, and just talk me through some hypotheticals here, that and let's look at a sort of a hypothetical but / real life scenario where there was a country that was perhaps in a civil war, or that didn't meet the definition of international, but there was an armed conflict within that country, and there were two warring forces, and Australians were being harmed or threatened or killed as a result of one or both of those actions. Do you foresee that in those circumstances where there was a civil war within the confines of one country, or where there was a blurring of the definition of what territory might fall under the one country, that could fall under the new proposed provisions?
Speaking purely hypothetically, as your question was framed, because it is not in the context of an international armed conflict, this regime potentially applies. In a civil war, as you say, what we'd have to look at is whether there is a state sponsor of terrorism at play there. So a state sponsor of terrorism is a listed foreign state entity that has and I'll paraphrase here, engaged in, fostered, supported or advocated terrorist acts against Australia. So if a state entity has been listed...
Australia.
Yes.
So what I'm concerned about is that if we had Australians in a country that was at civil war with itself and one or both of the protagonists were bombing or just indiscriminately killing civilians, and Australians happened to be a part or caught up in that, even if one of the protagonists was the official defence force of that country, would that official defence force or the other protagonists potentially be caught by this bill?
So, to answer the question in relation to are they essentially eligible of being listed as a state sponsor of terrorism, so just to sort of step through that process, they would have to be a foreign state entity, so an armed force could be a foreign state entity if they're part of the government. Then we go to their conduct. Is their conduct... and again, just to focus on the relevant aspects, engaging in terrorist acts targeted at Australia. Targeted Australia
or Australians.
Sorry, let me. So the targeted Australia is defined, and that includes both. It includes a range of circumstances. One is where Australians are harmed, even if that is offshore. So in that case, they would be captured. But just for completeness, to explain to you targeted at Australia as it's defined in the Act. So it is any sort of acts or threats of actions done in Australia. It is acts that seriously harm Australians, serious property damage, and works through all of the range of conduct captured by the physical part of a terrorist act. So, serious damage to property, interfering with electronic systems, endangering lives, all of those. And then finally, where the action or threat of action is intended to intimidate or coerce the Australian government or a state or territory government, or intended to intimidate the Australian public or a part of the Australian public. So just summarising that, really what it is, an act is targeted at Australia where it occurs in Australia, where it is intended to intimidate or curse the Australian government or the Australian public, even if the physical acts occur offshore, and that can include sort of damaging Australian property, as well as any acts, including offshore, that seriously harm Australians or seriously harm Commonwealth or state or territory-owned property. So think of a consulate or an embassy. So when we say targeted Australia, that is Australia and Australian within our geography, plus Australians offshore or permanent residents offshore, or Commonwealth or state or territory-owned property offshore.
Yes, I'm not sure if I'm making myself very clear. I understand what you're saying, but the provisions would be triggered, as I understand it, if in a case of a civil war overseas where Australians were killed or even targeted, then that potentially would bring the state-sponsored provisions of this legislation into being.
Yeah, so there's an important distinction there, and I understand what you're saying, but why I've been talking about the listing decision in answering you is these provisions only apply to state sponsors of terrorism. They are foreign entities that have been listed. So in that situation, for the criminal offences to apply, first the regulations have to be made to list that entity as a state sponsor of terrorism, and then the criminal offences can apply.
No, I absolutely understand that. But in order to list the state sponsor of terrorism, the state sponsor of terrorism must have committed or threatened to have committed certain actions against Australians, and that could be in their own country. It could be extraterritorially.
Absolutely.
So the answer to my question, and I'm not trying to put words in your mouth, but I am trying to get a very clear answer from you because I think this is a very, very important question. The answer to my question is yes, is it not?
It's a foreign state entity who targets Australians offshore where those other factors are met could be eligible to be listed as a state sponsor of terrorism.
And is there in those circumstances where I want to draw a parallel or a distinction, I want to draw a distinction here between the intentional targeting or threatening of Australians and Australians being, for want of a better term, caught up in a conflict. Even if the state sponsor was involved in acts of terrorism, under the current parallel, the current system, it could be against our allies as also, couldn't it? Could it not?
Yeah, so you have two parts of it. One, have they engaged in a terrorist act? And the second part of it is that terrorist act targeted at Australia. So,
or its allies.
So the targeted Australia part is limited to. I walked that definition a minute ago, but is focused at Australia exclusively. Now, when there are acts targeted at allies, they may come within the scope of that. You may target an ally, and in doing that, harm Australians or be intending to also intimidate or coerce the Australian government. So it would depend on the factual circumstances there. But I
just know that when these listings come before the committee, and the committee is considering whether the organisation or group should be listed, the question usually arises as to whether there's a risk of Australians being harmed overseas or our allies being harmed. And I'm just trying to understand from you whether under this parallel universe those same provisions apply.
Yeah.
Perhaps if I can give you an example, if it wasn't Australians that got caught up in a civil war that we've been discussing, and it was Americans or Brits, would that potentially trigger the provisions?
It would have to, the terrorist act would have to be targeted at Australia, so it would have to be, in this case, it's not done in Australia, but there would have to either be serious harm to Australians or to paraphrase, Commonwealth property, or would have to be intended at intimidating or coercing an Australian government, or intimidating the Australian public or a part of the Australian public. So there has to be that nexus with Australia.
So where does the ally element come into it when we've been when that issue has been brought to the attention of the PJCIS, when we're considering whether to list an organisation?
So in Part 5.3, so when So in listing a terrorist organisation at the moment under Division 102 of the Criminal Code, and all of the many listings you've reviewed in the committee, Terrorist Act in that circumstance does not have this nexus to Australia requirement. So a non-state entity or an organisation engaging directly or indirectly in terrorism or supporting terrorism or advocating terrorism anywhere in the world against anyone would be eligible for listing under that regime. This has that distinction of it has that additional requirement of a nexus to Australia that does not exist for current terrorist organisations. So where ISIS targets allies, they are eligible for listing, even if there is no connection or no threat to Australia under Division 102. In this case, a foreign state entity must have engaged in acts that were terrorist acts that were targeted at Australia to be eligible for listing.
I'm not meaning to be difficult, but I just want to make sure that you are given every opportunity to give fulsome evidence. But when you say targeting Australia, you are also including on your, well, I understand your previous evidence that includes targeting Australians.
Yes, so targeted at Australia as defined in the bill, which includes targeting Australians.
Yeah, okay. But it has to be an express targeting of Australians. It wouldn't cover situations where someone got caught up in armed conflict.
No, it could capture that situation. Yes,
it could.
Yeah.
So, can you just talk us through the elements of the intentional targeting? Because I'm trying to follow your reasoning that if a state sponsor targeted Australians offshore in country X, they could fall foul or be caught by this new provisions. But even if they didn't target Australians directly and Australians got caught up in the conflict, that would still fall under the relevant definitions of this new provisions.
Yeah, so 110.3 subsection 3 of the bill says the AFP minister must be satisfied on reasonable grounds that the entity is a foreign state entity and the entity has, and to target the point, I'll paraphrase, directly engaged in a terrorist act that was targeted at Australia. 110.2 of the bill or the new provision then defines what it means for a terrorist act to be targeted at Australia. A terrorist act is targeted at Australia if, of the various alternate provisions, the action causes serious harm, that is physical harm, to a person that is an Australian citizen or an Australian permanent resident.
Okay, so the action causes serious harm. There's no intention. There's no intent element on the part of the foreign state actor to ensure that it was an Australian.
That's correct. So there has to be, it has to be a terrorist act. So it has to meet those other criteria of a terrorist act. But for a terrorist act to be targeted at Australia, one of the ways it can meet that definition is if the action that is the terrorist act causes serious harm or endangers the life or causes death of an Australian citizen or an Australian permanent resident.
Okay. So could there, under this regime, in an instance where an Australian was killed or harmed in Gaza, for example, could the IDF be listed as a listed terrorist organisation?
Look, I'm not comfortable on commenting on a particular factual circumstance, but what I can say is if there is a foreign state, a foreign military that is not engaging in an international armed conflict but engages in a terrorist act, and that terrorist act causes serious physical harm to an Australian citizen, that it would be open to the AFP minister to be satisfied of that.
So if the relevant minister, the AFP minister, was satisfied that an airstrike was an act of terrorism, or whatever the type of violence was, then in circumstances, those circumstances, there is a possibility that they could be. And I appreciate you don't want to talk about specific countries, and I respect that, and that's fine.
Yeah, the methodology of a terrorist act, it's not prescriptive as to methodology. However you are committing the act or threatening to commit the act, the definition is methodology agnostic. So it could apply to like we've seen in all of the terrorist attacks that have occurred in the past. There is a wide range of methodologies used, but yes, it could conceivably include an airstrike. So long as all the other factors were met.
Yeah, exactly. We're not just sort of limiting. I know you're not limiting it, and I'm not limiting it to airstrikes, but any form of violence that endangers the life of an Australian or kills an Australian in a conflict which does not qualify as an international armed conflict. And that would be a whole other question. I understand that. I'm just concerned about the unintended consequences that could flow. And we've got a real-life example that I know you don't want to comment on, but it's top of mind for me about how that would apply if this bill is passed.
Deputy, I just want to, for completeness, we've been focusing a lot on the physical act and whether that is targeted at Australia. But when I sort of say they have to engage in a terrorist act, it is the physical act plus those other two elements as well. So just for completeness, that the intention of that act or threatened act was to advance an ideological, political or religious cause, and that action or threat of action was intended to intimidate or coerce the government or intimidate the public or a part of the public. So there are those additional elements there as well. It is not purely the physical conduct. There has to be those additional intention parts. But just for completeness.
Yeah, no, I really appreciate you. And I just want to make it perfectly clear, I am not trying to be difficult. I'm not trying to trip you up. I'm really just trying to drill down as to how this is going to work in practical reality and in what circumstances that we may not have thought, we may not have had any intention of covering what sort of unintended consequences are going to flow from this.
No, look, I appreciate Deputy Chair, and equally I'm not trying to be difficult. It's just a complex bill. Yeah, I'm trying to explain as best I can. One factor to just sort of add there as well is the unintended consequences of extending criminality to a foreign state were very much forefront of mind, and a big reason why, to go back to our earlier discussion about why we created a standalone regime to allow us to really target it and confine it. So when we talk about unintended consequences, how we've tried to alleviate or mitigate that occurring is ensuring that criminality doesn't extend to a foreign state entity without an active decision of government. So the AFP minister must be satisfied of those factors and must have obtained the agreement of the foreign minister to ensure that those foreign affairs and diplomatic considerations are all taken into account and we have a full picture before a recommendation is made to the Governor-General to list an entity. How this differs from the current arrangement in Division 102 is there is no self-executing pathway to prosecution here. So you're very familiar with the terrorist organisation provisions. Where an organisation is not listed as a terrorist organisation, the offences, majority of the offences in Division 102 can still be prosecuted. The prosecution just has to then prove that the terrorist organisation or the organisation was engaging in terrorist acts. Listing a terrorist organisation is an efficiency there where they don't have to prove that, they can just rely on the listing. This regime differs from that in that it only applies to listed state entities. So there is no self-executing pathway to prosecution. So no criminality is extended without a conscious and active decision. And you've got our Foreign Affairs colleagues up next who can talk more about the input that the Foreign Minister will make in that decision as well. But it is being framed to ensure that that full context is considered before the offences apply.
Yeah, no, I understand that. There's a check and balance there with it has to be, the listing has to be, or the government's intention to list has to be approved and signed off by the Foreign Affairs Minister, and any conviction, any prosecutions that might flow from the listing of such a state sponsor has to be equally signed off by the AG. I understand there's checks and balances, but if there was a situation where you had a government of the day that was hostile to a particular country, or maybe hostile is too strong a term, but I think you understand where I'm getting at. My concern is that these checks and balances aren't going to be worth the paper they're written on.
Yeah, I understand. The other bit I would add there, and in sort of carrying forward the parallel from the current terrorist organisation processes, there is the review process for this committee to review those and make recommendations, and the regulations that ultimately list a foreign state entity are disallowable by Parliament. So there is that broader scrutiny, for lack of a better word, by Parliament of those regulations as well. But ultimately, it is it's sort of a decision of the government to list.
Yeah. Okay. Chair, I've got a lot of other questions, but I appreciate them with colleagues. Yeah. No worries.
So
Thanks.
I know some of my colleagues are keen to ask some questions. Look, Ms. Lawrence, I think, has some questions. So I'll go with you, Tanya, and then I'll rotate the call back.
Lovely, thanks. Just to follow on from Mr. Wallace's line of questioning there, because you have spoken about the fact that there are, a lot of different in response to the opening question from Mr. Wallace about the purpose of the bill. So there is obviously a lot of other legislation, terrorism offences, organisation listing sanctions, counter-terrorism mission measures, perhaps even foreign interference laws could have been applicable in the context of the case against the IRGC with the attacks within Australia. And so I'm just interested to understand that where you defined what this legal framework enables is a more narrowly constructed powers, whether in fact that may then limit those broader powers that are already provided for. So I'm just wanting to see whether you've had any legal advice concerning the potential of those broader constructed powers being limited now by these more specific powers that we're discussing today.
Thank you, Ms. Lawrence. Look, what might be helpful is to talk about two separate things. Firstly, the other offences that may be applicable to certain conduct would be unaffected by this. So whether they are state and territory offences around, assault, arson, murder, or Commonwealth offences around foreign interference or sabotage or other things, would be completely unaffected in their scope. In terms of powers, and this gives me an opportunity to answer my unfinished part of the Deputy Chair's answer, so that's exciting. When we make a number of consequential changes, Mr. Wallace asked how the definition of terrorist act was changing in the Crimes Act. So the Crimes Act is where there's a range of police powers that come out of that. So what we are doing across the statute book, we have reviewed everywhere that there was a power or a framework or some sort of regime that referred to terrorist act being acts. Terrorist acts being acts not engaged in by a state, so a non-state entity. reviewed every one of those instances and made an assessment about whether that should also apply to a state terrorist act, being a terrorist act engaged in by a state sponsor of terrorism. So there's a significant number of consequential changes to other legislation as a result of that. One was to the Crimes Act to change Terrorist Act to include State Terrorist Act. So all of those powers available to police in relation to terrorist acts would also be available in relation to state terrorist acts. Similarly, there are a range of counter-terrorism powers in the Criminal Code, in Part 5.3, control orders, post-sentence orders, preventive detention orders. At the moment, they apply to terrorist acts. We're amending that to also apply to state terrorist acts. Now, there are, and if you have an opportunity to look closely at some of the latest schedules of the bill, you'll see a wide range of other acts that are being amended. I won't go through all of those. I'm happy to talk about any of them if there's an interest in particular ones. But really what that is trying to do is say whatever that framework, whatever the power or provisions, if they were dealing with terrorism, should they apply irrespective of whether it was a non-state or state actor?
Thank you. So I appreciate the harmonisation point, but are you saying there were deficiencies, or was it for the purpose of harmonising those laws? Did you identify deficiencies? Like, was the foreign interference provisions deficient for being able to make the case against the actions of the IRGC in Australia?
So in terms of the consequentials, no, there weren't deficiencies. These acts of state actors were not regarded as terrorist acts. So in recognising those as terrorist acts, it just makes sure that the other provisions move in step with that. In terms of why this bill was progressed rather than the foreign interference provisions relied upon, is really goes to again, I don't want to comment on the particular factual circumstances that the Prime Minister's announcement related to. But generically, what I can say is foreign interference, sabotage, state-sponsored terrorism is becoming an increasingly complex space. There is potentially some sort of overlap between those provisions, but that is certainly not complete. Ultimately, it will depend on the investigative agency as to which offence they would choose to pursue. So it's not addressing a deficiency in those provisions. They are targeted at something slightly different. This is to sort of address a new type of conduct that has occurred.
And you're confident that you've got the legal advice that these more specific powers are not going to now limit the broader powers that are currently available?
Yes, we are confident of that.
It's not going to be read down?
We're confident.
Okay, lovely, thank you. And then if I may ask, so the bill's offences for dealings with state sponsors of terrorism include a range of general defences, including the defence in dealings in accordance with court orders, payment of taxes and fees, official duties or functions of the Commonwealth, state or territory, and the official duties and functions of the United Nations or the International Committee of Red Cross. Are you confident that all potential legitimate dealings with state sponsors of terrorism are captured by these defences? We've seen the submission, for example, from Save the Children, where they're looking for a broader humanitarian exemption as an example.
Thank you. So those general defences have been crafted as carefully as we were able to make them to deal with legitimate dealings. Aspects of those are unique to this framework and don't exist for terrorist organisations, really because of that, the legitimate dealings that citizens may or non-citizens may need to have with a state entity ultimately, we will need to look at any organisation that is listed to ensure there is sufficient protections there, and those defences have been framed in such a way to allow that to occur. In terms of the Save the Children and the ACFID submission, we are aware of their concerns. We are, together with DFAT, directly engaging with them on those concerns. Their concerns, as they say in their submission, apply equally to this new part and the existing part 5.3. Any response to those needs to consider that comprehensively and across both divisions. So we will continue to work with them on those concerns, but any response needs to sort of ensure that both frameworks are moving as one to address any concerns there.
So appreciate it's nice that you're looking to how you might address the concerns, but is there a way in which we could give that consideration in the context of this legislation? Because I appreciate we've heard from the Save the Children, but perhaps particularly because of the strict liability provisions that there is a heavier risk imposed, and I just want to be clear that civil society, academia, not just humanitarian aid work, are not going to be inadvertently caught up in provisions where the onus is on them as well to potentially prove that they are aware of the executive decision to list a state entity and that their role in that conduct is not of terrorist in nature. So I'm just trying to be clear that there is sufficient defences because we've kind of limited by the list, but is there a way in which perhaps like the Canadian model or other countries have done that, have ensured that there's sufficient scope that people aren't inadvertently caught up in this that is not intended to be so?
So the equivalent defences are provided in the new regime as are provided in the current terrorist organisation regime. So there is certainly no less. In fact, there is more protections here for legitimate dealings. So some of those provisions you spoke to earlier do not exist for terrorist organisations because there are fewer legitimate reasons to engage with terrorist organisations. In this case, there being a state entity and in the context of sort of governments, there are additional protections built into this to deal with those circumstances.
And that, I guess, is my point, because my understanding, IRGC are funded through the Iranian regime. 2/3 of the defence budget is going towards them. So there's clearly in that instance a direct link, and this is just one example. We don't know what might be listed in the future. The Australian government has got ongoing diplomatic relations with the Iranian regime, notwithstanding the ambassador is no longer here. How will we ensure that people are protected from any legitimate dealings with the state entity?
Ms Lawrence, in the general defences, so under Divisions 112 and Divisions 113, there is a general defence in there for persons engaging in an official capacity on behalf of the Commonwealth or a state or territory, or a foreign government as well. So where foreign partners might be engaging with that government, they will be protected from the offending under those divisions by operation of those defences.
But we're, again, using the IRGC because that's obviously been the genesis for this legislation. They've got construction arms, they've got telecommunications arms, they've got business arms, scattered around the place. Again, is it limited to defined acts?
There are two particular provisions that may be relevant there. So one is the defence you mentioned earlier about where the conduct is engaged in compliance of a court order or a law relating to a fee, duty, various other engagements there. So there is that protection where you have to engage with them on that basis. That would be protected. There is also another defence, again, which is unique to this framework, which is about engaging with them in relation to the provision of a service, where that service does not relate to a terrorist act and it is not reasonably able to be obtained from a different party. So if you have a situation where the listed state entity provides a service in your community, there is nowhere else to get that service does not relate to terrorism, this provision provides a defence for that circumstance.
Thank you, Chair.
That's right. Just on that, I was just interested then, Luke, in terms of what are the consequences for not including the general defences?
Sorry, Chair, the consequences of not including the general defences?
Yeah.
So it goes to, it's the exact inverse of what we've just been discussing, where the unique nature of a foreign state entity and extending criminality to them is that there is potential there for legitimate engagement with them to be captured. So by including the general defences, we're ensuring that sort of legitimate or unavoidable engagement is not, is a defence. That may include where perhaps, and, wading to the dangerous waters of hypotheticals, but if a listed state entity also provided, they engage in terrorism, but they also provided visas for that country. So, or collected taxes or distributed some sort of fines in that country. Citizens or people looking to visit that country may have to provide money to that entity. We want to ensure that where that is, that is an entirely legitimate purpose, that is not being caught up in these offences.
Okay, and I think just from Liam's response, just speak on some clarity. So are the only defences available for engagement with a state sponsor of terrorism are those that are included at 112.8?
So to step it through, there are additional... there are a number of, if we just go into Division 112 at the moment, which are the offences in relation to engaging with a state sponsor of terrorism, there are a number of offence-specific defences. So, for example, the associating offence at 112.7 at subsection 5 has a series of carve-outs that are directly related to the associating defence. Such as if the association is with a close family member, that would be a defence. Then there are some general offences.
Can I just clarify though? But the defendant bears the onus of proof, though, right? It's not for the prosecution.
That's right. They are exceptions, and the evidential burden would sit with the defendant, meaning that they would need to suggest a reasonable possibility of that to discharge that evidential burden before the legal burden's transferred back to the prosecution.
Okay. So, did you just finish your answer to mine? Because I'm mindful I'll need to hand back to...
No, Chair. Just quickly. So there's some specific ones for specific offences. Then there are general defences for that division, and then the general offences that apply to all crimes at the front end of the criminal code, such as duress, self-defence, things like that, would also apply to these offences as they would to all offences.
And sorry, just another I just want to clarify another aspect of your response. So, are there other defences in the broader criminal code that apply generally to these offence provisions?
Yeah. So that's they are in. I will find them. Just one moment.
Yes. Okay.
At the beginning, Part 2.3 of the Criminal Code provides a series of defences that apply to all crimes, including these ones.
All right. Thanks, mate. I appreciate that. Okay, Deputy Chair, you've got the call again. You're on mute too, by the way.
Sorry, I'm happy to provide the call back, but I just wanted to pick up on
go for it.
Ms Lawrence's questioning there and try and keep the themes going. And I think Ms Lawrence raised some very good points and relying upon the submissions of Save the Children. What I'm struggling to understand is why the UN and the International Committee for Red Cross get a specific carve-out, but other humanitarian organisations don't get those same protections. Can you talk us through how you or why you did that?
Thank you, Deputy Chair. So I was just trying to locate the defence you're referring to. Really that goes to the nature of those entities and the functions they perform. So they have very clear, well-recognised sort of a global role in training people in international law, in national humanitarian law, involved in conflict situations, famine, all number of things, and really where we have extreme confidence in their mandate and the performance of their functions. In terms of humanitarian entities more broadly, it is something we need to consider. There is, in relation to the association defence at 112.7, similarly to the equivalent provision in relation to terrorist organisations, at 112.75C, there is a specific defence in relation to the association is only for the purpose of providing aid of a humanitarian nature. So there is a broad humanitarian defence there that wouldn't just apply to humanitarian aid being provided by those two entities, but really by any entity. Where it becomes a little bit more complicated is for the other offences, it's really a matter of working through those in turn. A lot of those offences have elements that need to be proved which require the person committing the offence to have some sort of involvement in a terrorist act, and therefore obviously a humanitarian purpose would not be relevant. So, for example, providing support to a state sponsor of terrorism, the person there has to intentionally provide to an entity support or resources that would help the entity to engage in the doing of a state terrorist act. So in that case where someone has intentionally supported someone to engage in a terrorist act, whether they also have a secondary motive, the culpability comes from that intention?
I'm really struggling with this now because there are instances where, very recent instances where humanitarian organisations have been certainly alleged, if not proven, to have had personnel involved in actual terrorist acts. So I'm struggling with your submission that, well, just because someone belongs to the United Nations, for example, that they should get a carve-out.
Look, I might refer you to part of the Department of Foreign Affairs and Trade's submission there, and it might be best to defer to them on this one.
Sorry, I might just draw your attention in terms of the general defences. It's not just has some association with its perform an official duty or function for one of those bodies. So those bodies' official duties and functions could not possibly, cover. So the fact that an individual working for that body might also do such a thing does not make what they did an official duty or function. If you follow, does that make sense?
No, I do. Thank you. Thanks for that clarification. To Ms. Lawrence's, I think, very valid point, why don't we look at some sort of a schedule where humanitarian organisations could be listed that would get these protections? To
refer to my earlier evidence, it is something that we're actively engaging with those entities on. We certainly understand and appreciate their concerns, and is something we need to work through together with them. That needs to be done in quite a considered way to ensure that we are not extending a defence to any agency to ensure that it is actually legitimate, rather than two individuals with malicious intent under a cover of a charity then get a carve-out. So it is an active conversation with them that we are working through that problem. So we're alive to it, and we're having that discussion. Like I said, we need to think about that for both terrorist organisations and state sponsors of terrorism, not in isolation. So across both divisions, both parts, and is a conversation that is ongoing.
Thanks very much for that. Chair, I'm happy to go back to you or to any of the other members.
I've got maybe a few questions, and I'll maybe then come back to you and then come back to other colleagues. But I just wanted to ask, does the bill make any amendments to the terrorist symbols provisions in the Criminal Code?
Yes, that's one where I referred to before, about where we've done that mapping across the statute book to look at everywhere that Terrorist Act, terrorist organisation is referenced, and made an assessment about whether that should be appropriately extended to state terrorist acts or state sponsors of terrorism. So in that circumstance, we have a definition of prohibited terrorist organisation symbol that is then picked up in the crimes around publicly displaying a prohibited terrorist organisation symbol or trading in a prohibited terrorist organisation symbol. So there what we've done is the bill will expand the definition of prohibited terrorist organisation symbol to, in addition to symbols of terrorist organisations, would also include symbols of state sponsors of terrorism.
So let's say that could the flag then of a nation state be considered a terrorist symbol?
Thank you, Chair. That is expressly carved out, noting the sort of importance of flags to citizens and citizenry and the legitimate usages. So the definition is a symbol used by a state sponsor of terrorism or part of that organisation to identify the organisation, or used by members to identify the organisation, and then it expressly carves out flags from being captured in that definition.
And what about the government being able to list an entire country as a state sponsor of terrorism?
So for that aspect, that goes to the definition of foreign state entity in the bill in Division 110. Foreign state entity is defined in the bill in a way that captures the entities that are eligible for being considered for listing, where they go on to meet the other elements of that threshold. That is really focused on governments of a country, or parts of governments, authorities of a government, or local government bodies. So it is the governmental entities of a country, not a country in its entirety.
All right. Look, I had a hand back to the Deputy Chair if he's got any other questions.
No other questions from colleagues, Chair?
Well, I haven't come to you. I'm acknowledging that.
Well, I'm very conscious that I've been asking a lot of questions. I want to make sure.
That's fine. And then we can come back. We can come back to other colleagues.
Yeah. I just don't want to be accused of being a hog, Chair.
No, I don't want to be accused of also just not giving you the call either too. So please proceed, Deputy Chair.
Oh, so you are going to me?
I am.
Okay, all right. Just stepping back a bit from the intricacies of this proposed bill, can you explain to me, because my understanding is that the United Kingdom, the United States, has listed the IRGC as a listed terrorist organisation. Now, I know that their legislation is self-evidently different from ours, but how is it that they were able to list the IRGC under their regimes, that's probably a poor use of the phrase, their legislative regimes, and we can't. And I'm just concerned that we are overcomplicating this when we may not necessarily have to.
Yeah, thank you, Chair. So just to clarify, it's the United States and Canada that have listed, not the United Kingdom. But to your question of how have they been able to look, ultimately it's the way that their regimes or schemes or frameworks are formulated, and how the legal interpretation of that works in terms of how it applies to organs of nation states. Our regime was formulated in a way that would not capture organs of nation states, but I can't comment on the intricacies of the US or the Canadian regimes and how theirs has permitted it, but only to comment on ours, which does not allow us to.
Can you draw the committee's attention to the specific provisions that you say that the current legislative mechanism prohibits the listing of the IRGC?
With your indulgence, Chair, I might take that on notice. I'm just very conscious of wading into providing legal advice, so I just want to be very careful. I understand the importance of that point. I just want to be very careful in the words I use. So if that's all right, I might take that one on notice.
Yeah, no, that's fine. I think you understand where I'm coming from. So, yeah, very happy for you to take that one on notice. I don't think I've got any other questions, Chair.
Okay. Thank you very much, Deputy Chair. Now, Senator Grogan, I think you've got...
Thank you, Chair. Yeah, I do have a couple of questions.
Okay.
The main amendments in the legislation are listed as either commencing on a date fixed by proclamation or 6 months after roll of send. The explanatory memorandum says that that's predominantly due to enabling further consultation with states and territories around 3.5 of the Criminal Code. Can you talk us through what conversations you may have had with the state and territories to date and what the intent is of those further consultations?
Yes, very happy to. So just to clarify, the main schedules commence by proclamation. The 6 month reference is that if a proclamation is not made within 6 months, then...
I'm fully aware of that. It's just that the memorandum, the explanatory memorandum, specifically states that part of that reason
is because
it refers directly to it. That's hence my question.
Yeah. So really, part of the when I spoke earlier about the requirement to go through the statute book and look at ensuring that police have the appropriate powers to respond. Part of that was extending the current terrorism powers to these state-sponsored terrorist acts. A number of those powers exist in Part 5.3 of the Criminal Code. That part relies on a referral of powers. So we can't amend that without obtaining the agreement of a majority of the states and territories. So as part of this, we have been engaging with the states and territories, both in the formulation of the bill, knowing ultimately that they will have to approve those changes to Part 5.3. We've done so through the Australia-New Zealand Counter-Terrorism Committee Forum, which is the forum which we sort of the premier forum for engagement on counter-terrorism issues with the states and territories, as well as the legal issues working group underneath that. The Attorney-General has also written to her counterparts in the states and territories in relation to the bill. And the Prime Minister has now written to First Ministers seeking agreement to the bill. So that process is happening concurrently, and some of those First Ministers have already provided agreement. So that process is sort of happening concurrent with parliamentary consideration.
Okay, and thank you. That makes perfect sense. Is there any sort of state or territory legislation that may need further amendment from this?
Ultimately, that will be a matter for the states and territories, but it is something that we have been discussing with them. Similar to where we did that review of the statute book and references to Terrorist Act, terrorism, terrorist organisation, they will need to do that same process. And that was also a driving factor for us engaging with them in the development of it, so they were starting to think about that. And we'll continue to support them in their reviews to make, if they determine appropriate, amendments to their own legislation.
Okay, thank you. That's really helpful. Different topic. What would be the ongoing role for this committee in reviewing listings of state sponsors of terrorism and also in monitoring and reviewing the AFP functions under the new provisions?
Thanks for your question, Senator. So the functions of this committee under the bill would mirror those in some ways with a slight difference. So it would mirror those in the existing Division 102 of the Criminal Code. So the committee would be able to review a new listing or any listed entity under the scheme by an own motion review. There is also amended provisions for disallowance to allow for parliamentary consideration of any report this committee did make with respect to a new listed entity. Review at any time, sorry, I think I said that. The main difference I think I hinted at earlier with respect to the committee's functions. Senator, the second part of your question I think was about review of the AFP's functions. So the amendments to the bill include amendments to the Intelligence Services Act that would allow it to review the AFP's data retention functions. The existing provisions capture Part 5.3 of the Act. That relevant provision of Section 29 would be amended to also capture the new Part 5.3A of the Act with respect to those functions of the AFP.
So there's a difference between what was and what will be. If we go back to Mr. Wallace's original sort of parallel points, the bill doesn't extend the PJCIS role to monitor and review the AFP functions under 5.3A in the manner that it does in 5.3.
So to be clear, it gives the PJCIS the exact same powers to review listings as well as to sort of review the data retention requirements. The AFP are provided no functions under Part 5.3A. AFP are provided a range of functions in 5.3 in relation to control orders, preventive detention orders and control orders. As I mentioned earlier, the definition of those powers and functions are being expanded through amendments to Part 5.3 to also include state-sponsored terrorist acts. So the use of AFP's functions under 5.3 will apply. The AFP's functions under 5.3 will apply equally to terrorist acts and state-sponsored terrorist acts. So PJCIS's jurisdiction there would be expanded to also include them exercising those functions in relation to state terrorist acts.
Okay, so we still have the same ability across the whole intent of this new legislation?
Yes.
Yep. Okay.
Look, can I jump in there, Karen? Sorry. When I look at the Intelligence Services Act, paragraph 29.1BE, and then at 29.1BAB, this is the line of question I think where Karen was going with, that yes, we retain the retained data activities of the AFP, but it doesn't appear that we retain the AFP's performance of its functions under Part 5.3.
Chair, the AFP isn't provided functions under 5.3A. So 5.3A has offences and a listing framework. When you compare that to 5.3, that has the listings framework and the offences, but it also then goes on in divisions 104, 105 and 105A to provide those power regimes, and that is where AFP's functions sit.
Okay. All right. Well, hopefully that helps. I just wanted to get that on the record to clarify, because I think it's an area that we just wanted to ask. Andrew, you had your hand up. Deputy Chair.
Yeah, no, I was just struggling with that issue of the senators as well. I'm not quite sure I'm the wiser, to be honest.
Well, we'll no doubt take on board what's been presented, but I think there was just something there that's just worth just checking in terms of the sometimes things do get missed when you're looking at other pieces of legislation, but I think Luke's provided a response that we'll no doubt review as a committee.
Chair, if I could just have...
Certainly makes sense to me now, thank you.
Okay.
Senator Grogan, hopefully that satisfies you, or if you had other questions, sorry to interrupt your flow.
No, that has answered my question and it makes sense to me. So, no, I appreciate that point of clarity. I have no more questions, Chair. Thank you.
Sorry, Luke, did you need to add something there?
I was just going to have another crack at it, but Senator Grogan's happy, so I'm happy.
I'm not.
Another crack
for the Deputy Chair, essentially the new framework is about creating a parallel regime for the framework for listing and the offences. We have not created a parallel framework for the functions and the powers. The powers regimes in 5.3, how we've expanded them to state terrorist acts is through directly amending those provisions in 5.3. So AFP's powers are extended to state terrorist acts through amendments to 5.3. So PJCIS's review of the performance of it, you are still reviewing their performance under 5.3.
Yeah, the penny's just dropped. Thank you.
All right. Thanks. Look, I think on that note, given that we've got the Department of Foreign Affairs and Trade, and I'm pretty eager to get to them as well, I'm sure everyone else is, just wanted to say thank you very much to both the Attorney General's Department and the Department of Home Affairs. As I said, if there were any questions that were taken on notice, could you please provide responses within 24 hours of receiving the Hansard transcript, but no doubt the Secretary will be in touch with you. We'll just suspend just briefly and get ready for the Department of Foreign Affairs and Trade.
Yes, Chair.
Okay, thank you. All right, I now welcome representatives from the Department of Foreign Affairs and Trade to give evidence today. For the Hansard record, could you please state your full names, the capacity in which you appear today?
Thank you, Chair. Matthew Fox, First Assistant Secretary, International Security Division.
Thank you, Chair. Claire Shepherd, the Acting Director of the Counter-Terrorism Asia Section.
All right. Now, although the committee doesn't require you to give evidence under oath, I advise that this is a legal proceeding of the Parliament and therefore has the same standing as proceedings of their respective houses. Given false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. Now, due to the short time frame the committee is working within to complete its review, please try and answer all questions or provide information to the best of your ability in the evidence today. As further written answers to any questions taken on notice will have to be provided within 24 hours of receiving the Hansard transcript. Did you have an opening statement this afternoon?
No, Chair, but I just would draw the committee's attention to the Department of Foreign Affairs and Trade's submission to this inquiry.
Thank you. All right, Deputy Chair, I'm happy to hand the call over to you.
Thanks very much, Chair. Thanks, Mr Fox and Ms Shepherd. What sort of diplomatic risks might be involved in the making of regulations under the proposed new framework, and how would these risks be balanced with the need to keep Australians safe?
Deputy Chair.
It's happened twice today.
It's a sign.
Good grief.
We assess that the bill sets out an effective and proportionate framework to balance Australia's national security, diplomatic, foreign policy, legal and humanitarian interests. And to support that, we think there are a number of necessary safeguards to support its operation. In terms of the framework, we assess that it's appropriate and necessary that the Australian government has frameworks which allow the threats posed by terrorist organisations and state sponsors of terrorism to be addressed in a bespoke manner, and that establishing separate state sponsors of terrorism framework and associated offences reflects the seriousness and complexity of the terrorist threat posed by certain foreign state entities towards Australia.
Mr Fox, correct me if I'm wrong, but under the proposed regime, the Minister for Foreign Affairs has a right of veto over whether a state-sponsored or a state sponsor of terrorism would be listed. Is that correct?
Senator, you're quite right that the bill does set out a very clear role for the Minister for Foreign Affairs in the listing of an entity as a state sponsor of terrorism. To very briefly recap that, the provision reflects the significant foreign policy and diplomatic considerations that are inherent in any listing under the proposed framework, and seeks to...
Yeah, but this is very different, though. This is very different, this listing, though, because you're as opposed to listing an organisation, we're talking about the Australian government being empowered under this bill to list an organ of the state of another country. It's very different.
Yes, you are correct, Deputy Chair, and it's for those reasons which the proposed framework in relation to state sponsors of terrorism does include that formal role for the Foreign Minister. The Foreign Minister is able to agree to a decision, and in making that agreement, the Foreign Minister would have regard to diplomatic considerations, humanitarian, consular, legal, a whole range of factors, which is an appropriate safeguard in this regard, which does maintain the importance of Australia's diplomatic relationships.
Are those, is the framework that you talk about the considerations that the Foreign Affairs Minister would need to take into account, are they enshrined in proposed section 110(3) subsection 5, or is it just that the Foreign Minister needs to take certain considerations into account? Is it set out what she must consider?
Deputy Chair, under that provision, it provides for the Foreign Ministers that the Foreign Minister needs to agree, her agreement needs to be obtained in writing before a regulation can be made specifying that the entity is a state sponsor of terrorism.
Yeah, but what are the considerations that he or she is required to take into account under the bill?
There are no formal requirements enshrined in the legislation, which has been an intentional choice. It's appropriate that the Foreign Minister does have appropriate flexibility in relation to considering the humanitarian, consular, diplomatic and foreign policy matters, which may be different on a case-by-case basis.
Is that a potential problem that effectively we're asking the Foreign Minister to exercise a very broad discretion without giving him or her, I should say her or him to be more relevant, her or him some clear guidelines by which they should be operating? I appreciate you don't want to fetter the Foreign Minister. I'm not suggesting we should. I'm just wondering whether there should be some clearer guidelines by what they should exercise that discretion.
Deputy Chair, I think if I was to think about it from a process standpoint, the AFP Minister needs to be satisfied on reasonable grounds that a foreign state entity meets the legislative criteria, and then in the Foreign Minister needing to agree to that balances the full span of Foreign Minister responsibilities, which certainly includes national security considerations, but it also considers our bilateral relationships, our international security and foreign policy interests prior to any listing being made.
I'm sorry, I'm just trying to formulate my questions, but are those factors listed in the ledge about national security, bilateral relations, foreign relations, or is it just left open to the discretion of the Foreign Minister?
Deputy Chair, it doesn't specify under this section those considerations, but the essential piece is that should the AFP Minister be satisfied on reasonable grounds that a foreign state entity meets the legislative criteria to be listed as a state sponsor of terrorism, it's essential that the Foreign Minister's agreement be obtained beforehand to, if you like, capture the full foreign policy equities that the Foreign Minister is responsible for, which includes, as I set out, things like our bilateral relationships, our international security and foreign policy interests.
Yeah, I'm wondering why, and I appreciate Ms. Shepherd's point that you may not want to fetter, and I'm not suggesting that the Foreign Affairs Minister should be fettered. I'm just concerned that the proposed legislation doesn't give her zero guidance as to how she or he should exercise that discretion. Why couldn't you just say, when exercising the discretion as to whether to approve the listing, that the Foreign Minister would take into account the following matters, including but not limited to?
Deputy Chair, I would need to defer to the drafters on the exact choice for the drafting of the bill, but I suppose to reflect on, if you like, the spirit of your question, I think one thing that I am immediately drawn to is that the Foreign Minister is an essential member of the National Security Cabinet And so that full spectrum that you're alluding to and that I hope I've set out in my response is inherent in the role of the Foreign Minister in performing their duties. And in this case, we have the AFP Minister exercising or being satisfied on reasonable grounds that an entity meets the legislative criteria and that the safeguard to reflect the foreign policy interests and concerns of the country is that the Foreign Minister agree.
Yeah, look, okay, I won't press that point any further. I think you would probably understand, I'm hoping my colleagues understand my concerns. To the check and balance of seeking the imprimatur of the Foreign Minister, I'm going to go to a hypothetical, but if you had if you had an Australian government at some point in the future that was not well predisposed of a government or an organ of the government of another country, I just wonder how much of a check and balance this is for the foreign to have the foreign or require the Foreign Minister to sign off on it. Has any consideration been given to any other form of check or balance? And I know you're going to talk about the Attorney General being required to sign off on any prosecutions, but putting that aside, we're talking about the list.
Deputy Chair, I suppose in response to your question, if you like, this provision for the Foreign Minister to agree before any listing can be made actually reflects the inherent significant foreign policy implications of any listing, and it ensures from a foreign affairs perspective that appropriate measures can be undertaken to safeguard the safety and security of diplomatic staff and Australian officials who may be posted or deployed in that foreign state. But the other thing it is a significant extension beyond what might otherwise be, which is, if you like, the standard processes of ministerial consultation or a deferral to, for example, the Federal Executive Council.
All right, I don't know that you've answered my question, but has any consideration been given by your department or in your discussions with the other departments any other form of check or balance?
Deputy Chair, I think from my perspective, it was important when we were working with our colleagues to ensure that the Foreign Minister's equities in this matter were captured because, as I said, inherently there's deep foreign policy implications, and we're certainly satisfied that this provision gives the Foreign Minister the capacity to exercise her role, which is inherent in any such listing.
No, look, you won't find the argument with me on that point. My concern is that it's unfettered, really, and that we're not giving her any direction, or him, depending on who it is at the time. We're not giving the Foreign Minister any legislative direction in this regard. And my concern is that a government in the future that could be I don't want to use the term hostile, but is not predisposed to another government of another country, where you've got a situation where the Home Affairs Minister is satisfied that a terrorist act has been committed or is likely to be committed. I just wonder how much of a check or balance that the Foreign Minister is being provided with a relatively unfettered discretion here?
Deputy Chair, it's difficult to speculate or offer opinions on scenarios without having the chance to think about them. But I guess the context of this legislation...
Well, I hope you've thought about these.
What I was going to say, Deputy Chair, though, is in the context of this bill and the backdrop to the development of it, we were certainly thinking through what would be the appropriate role of the Foreign Minister in the circumstances, and we're satisfied that it's important that the AFP Minister be satisfied on reasonable grounds that a foreign state entity meets the legislative criteria under section 110(3), but then that the bill in turn provides a provision for the Foreign Minister's essential agreement to be obtained.
Okay. I'll go to one more question if that's okay, Chair, or if you want to go to my colleagues and come back to me.
That's okay. That's fine.
The bill creates offences for directing the activities of, being a member of, recruiting for, training, getting funds to or from, providing support to or associating with a listed state sponsor of terrorism. The offences would have Category D, extended geographical jurisdiction, meaning they apply regardless of whether the conduct or the result of that conduct takes place in Australia or overseas. How would the new criminal regime sit alongside the existing sanctions regimes?
Thank you, Deputy Chair. First, I would like to make the point that those offences are contained in the terrorist organisation listing framework as well, so they have been inserted into the state sponsors framework in parallel. However, specific comment on the legislation should be directed to the Attorney General's Department. However, in relation to the Australian sanctions framework that is administered by the Department of Foreign Affairs and Trade, it is a separate framework which operates under the Charter of the United Nations Act 1945 as well as the Autonomous Sanctions Act. These frameworks could operate in parallel, and as part of the sanctions framework, the Foreign Minister also does have a role in reviewing sanctions.
So when you say they would work in parallel, can you just explain a little bit more of that, please?
So with the Australian sanctions framework, that operates under separate legislation. The bill as proposed with the State Sponsors of Terrorism framework does not make any changes to Australian sanctions framework. It would continue to operate and be administered by the Department of Foreign Affairs and Trade.
Okay, so no changes. Do you foresee any problems or unintended consequences that might arise due to foreign diplomats or other officials that Australia deals with being considered criminal offenders under Australian law if they associate with a listed state sponsor of terrorism?
Thank you, Deputy Chair. In relation to your question, the general defences are, again, an appropriate and proportionate measure. One of those general offences does allow government officials to continue engagement overseas as necessary. That was an important carve-out from the perspective of the Department of Foreign Affairs and Trade, as we do have posted staff present globally, and it is appropriate that there is a carve-out for persons performing official duties or functions.
Okay, and with your indulgence, Chair, I will just ask one more question, and that goes to the issue of the humanitarian organisations. That I don't know if you heard our questioning beforehand. Does DFAT have any concerns about the current regime and then the new proposed regime not providing adequate protections to humanitarian organisations?
Deputy Chair, I suppose I would start with saying that the arrangements are aligned with Division 102 of the Terrorist Organisation Framework, which similarly outlines a specific humanitarian exemption.
But only for specific organisations like the UN and the ICRC.
Well, our assessment is that this is appropriate in relation to state sponsors of terrorism.
So why do you say that?
I know the bill does not propose a broad humanitarian exemption, but as Divisions 112 and 113 set out, there is a general defence for offences which are applicable to persons performing official duties for the UN, agencies of the UN or the International Committee of the Red Cross. And I know you touched on this earlier with our colleagues from the Attorney General's Department, and these entities, in our assessment, have robust assurance and safety mechanisms to manage the risks associated with delivering assistance in areas where a state sponsor of terrorism may be operating.
Okay, I'll leave that statement. I won't challenge that statement. That's your view. I don't necessarily agree with it, but that doesn't mean in and of itself that other humanitarian organisations shouldn't be given the same sort of protections if they were to satisfy the Department of Foreign Affairs and Trade that they were acting with bona fides. I appreciate you don't want to give every organisation a potential humanitarian carve-out because that would be very problematic. So I mean, I absolutely understand that, and I congratulate you on that. But it seems to me that there could be a situation where we may be being too restrictive. And to Ms. Lawrence's point earlier, I hope I'm not verballing her, that why can't we look at some sort of a regulation arrangement where particular organisations might be listed to get those protections?
Deputy Chair, I'll pass to Ms Shepherd, but before I do, I just would say in our assessment it was appropriate that the scope of the humanitarian exemptions that are set out in this bill mirror the existing humanitarian exemptions that are available under the terrorist organisation listing framework.
That's a very diplomatic way of putting that, and it's probably appropriate that you're in that department. But would that mean that if changes were made to the current arrangement, then you'd be quite happy with those sort of changes being made to the new proposed bill arrangements?
I wouldn't offer a personal opinion on the matter, but I would state that the Department of Foreign Affairs and Trade does engage closely with humanitarian organisations, and we certainly acknowledge the submission by ACFID and Save the Children, which you have received. It's our evidence that it would not be the appropriate vehicle to progress such a change in this current bill. We'll continue to engage with humanitarian organisations as appropriate to determine what may be a suitable approach.
Yeah, it's kind of a little bit like, if not now, when? If there's an acknowledgement that there's a flaw in the existing regime when it comes to the protection of humanitarian organisations, why not fix it now?
Okay.
We certainly wouldn't view it as a flaw under the State Sponsors of Terrorism framework. That is because the gravity of the acts that would form the basis on which a listing is made are significant. Any change to humanitarian exemptions would have to be carefully considered. It's something that does take time, and given the significance of a listing, we would want to be absolutely certain that it's something that we got right.
How long has this been under active consideration by DFAT to amend the existing regime in relation to the protection of humanitarian organisations?
Senator, I think just for accuracy, I'll take that question on notice and get back to you quickly.
Yeah, okay. All right, that's all I have, Chair. Thank you.
All right, thanks very much, Deputy Chair. I don't believe there's questions from other members of the committee, so there being none, I just want to say thank you again to the Department, Foreign Affairs and Trade, for appearing, and I thereby declare that this public hearing is now closed.